So the speaker for today is James Atta Agaba. He is currently a lecturer at the Nigerian Law School, Kano campus, after teaching variously at the Abuja and Yola campuses. He taught civil procedure, criminal procedure law of evidence and law in practice at various times. He was a member of the editorial board of Nigerian Law and Practice Journal, Economic Crimes Law Report, and recently served as a member of the expert working group on the revision of laws of the Federation of Nigeria 2004. Bound by duty to teach criminal law and practice, he has affection for alternative dispute resolution. He's an associate member of the Chartered Institute of Arbitrators UK, member of the Chartered Institute of Mediators and Conciliation, and also a CEDR UK certified mediator. He was head of litigation department and head of academics at the Yola campus of the law school before his appointment as the Deputy Director General and head of Kano campus, Nigerian Law School. He currently teaches criminal and civil litigation. He has published many articles in peer-reviewed journals, both locally and internationally, and has also authored some texts on litigation. Has a PhD in law, is a member of the Yola branch of the Nigerian Bar Association. It is my privilege this afternoon to welcome Dr. James Atta Agaba. Dr. James, the floor is yours.
Okay, thank you so much, distinguished chairman. It's my pleasure to be with us today again. It's good to be here. Like you mentioned rightly, Mr. Chairman, I think the participation at this webinar is reducing because a lot of us go to the YouTube, believing that whatever was done, we'll find there. But then it's not supposed to take the place of interaction. There's a whole lot that we can actually gain. We can ask questions. We can learn a whole lot. I mean, from participating. I mean, with others, instead of having to watch it in our own spare time only. But even then, nothing is lost. This afternoon, we're going to be looking at closing addresses. I don't know whether my screen is being shared now.
Yes, Doc, it is being shared now. Thank you.
Oh, okay. Now, so we are looking at today. We are looking at closing addresses, and closing addresses closing address is just something that anybody who has been in litigation has done time and time again. So it's not something that is entirely new. We've all been doing it, and just like all the topics that have been dealt with in the course of this 12 weeks period, these 12 training sessions, there's nothing that is entirely new to us. It's just that we're all coming in to refresh what we already know. And then perhaps we just add to what add a little thing, maybe a little knowledge, a little way of doing something differently. That's just how it is. And so we're dealing with closing addresses. And closing address is one of the most fundamental parts of criminal trials or criminal litigation, because of the constitutional coloration that it does have. Usually after the case has been concluded, the parties' cases have been concluded. Since we don't use opening address here, mostly in Nigeria, after the case of the parties have been concluded, usually the parties will have to address the court. So addressing the main purpose of this address is just to let the court know the angle from which the defendant or the prosecution, as the case may be, want the court to view the evidence led as well as the law that is applicable. So we're saying that closing address, which is also referred to as a final address or closing statement in some jurisdictions, it refers to the submissions, it refers to opinions, it refers to suggestions or propositions put forward by counsel or a party on how the judge should view the evidence presented by the parties in addition to the applicable law. So so this closing address is actually your own, it's actually an expression of opinion. You know, as you have looked at the evidence that have been put in, you are supposed to sum up, to let the court have a guide. More or less with a closing address, you're helping yourself, you're helping the judge also to look at certain area more critically, even while downplaying some areas that are not favorable to you, irrespective of what the rules of professional ethics says. I don't think anybody will want to actually open up himself. Anyone that doesn't favor you really is natural that you will not want to really highlight it, irrespective of what the rule says. So the provision, section 304 of the ACJA and of course section 269 of the ACJL of Lagos all provide for, I mean, both of them provide for a closing address at the end of the case. I mean, the parties are entitled to address the court. Like we said, the party who is making the address, whether it is the defendant or the prosecution, will normally refer the court to the evidence that have been led, I mean, and the state of the law on each issue raised before the court, based on the facts that have been presented before the court, whether it is oral testimony, or documentary evidence, or real evidence, or circumstantial evidence. So he refers the court to the evidence that have been led, I mean, and then of course on the state of the law on each issue that has been raised based on the evidence that have been presented. Of course, facts that favor the party, I mean, that are obtained in chief are referred to. Evidence that are favorable to the party, elicited in cross-examination, is also highlighted. And of course, we know that evidence that is elicited during cross-examination usually seem to carry more weight than what is obtained in chief, just like Dr. Onoja and Dr. Dox made the reference to 2 weeks ago when we're dealing with trials. So the purpose, one now asks, what is the purpose of the closing address? The purpose is to enable the party addressing the court present to the court the summary of the facts, which in his opinion has been proved or disproved in the course of the trial. It affords the counsel the opportunity to marshal his argument properly. So the purpose, one of the things that one of the purposes that closing address has or serves is the fact that it gives opportunity to a party or to a counsel who is making the closing address to be able to marshal his point properly. At the point of closing address, evidence have already been led. Everything that needs to come in have come in. We've even gone beyond the point of saying, oh, no case submission and all that level, we've passed them. So the evidence that is before the court is what the counsel is going to address on. So it enables the party addressing the court to present to the court the summary of the facts, which in his own view, that is in view of counsel making the address, have the facts that have been proved and the facts that have been disproved in the course of that trial. A note of warning, though, is the fact that as important as closing address is, doesn't take the place of evidence. It is not a substitute for evidence. Having that at the back of one's mind at the beginning, of this discourse is very important, because a lot of counsel, if you are in court these days, you will see some flowery submissions, very beautiful addresses that are made by counsel. But then when you look closely and you try to examine the evidence that have been led, you discover that there is a disconnect. No matter how beautiful the submission may be, no matter how beautiful the address may be, if it does not stand on evidence that have been led, it goes to nothing. Everybody will say, oh yeah, your address is fine, your address is this, but then it's just like you have just cited authorities that don't have any leg to stand on. So all that the closing address does is just to help our counsel to at least attach his own opinion to the facts that are presented before the court, having in view what the state of the law is, and is urging the court to see that, look, this opinion I'm expressing, I want you to buy that opinion. I want you to see it from the angle I am seeing it. Essentially, that is what it is. So like we said, it is not a substitute for evidence, just like the court has, variously held. Like we have Oluwaniyan and Adeni here, and then Ukule and Adesoyan, where the courts have made a pronouncement in that regard. Another thing about closing address that is important is the constitutional flavor that it enjoys, because denial of a right to denial of a right to address the court has been held variously as a denial of fair hearing. Because when you have regard to section 294 sub 1 of the Constitution, you will see that right to address the court more or less has become a constitutional right, because the Constitution makes reference to the fact that the time that that judgments shall be delivered within 90 days from the conclusion of trial and final addresses. So final address is mentioned specifically in the Constitution. And that goes without saying that time for delivery of judgment does not seem to start to run until final addresses have been given, unless parties or any of the parties say, no, I'm not interested in delivering any address. If not, this is supposed to be taken into cognizance. That you see in the case of Okoevo against Police Council as well. You cited citation given there. In that case too, in this Okoevo's case, the court also held that it is wrong for a court to adjourn a matter for judgment without asking for final addresses, especially where parties are represented by counsel. That is wrong for a judge to adjourn. But if a court is adjourning a matter at the conclusion of trial, at the conclusion of evidence, it's supposed to adjourn for final addresses. So, but if you adjourn for judgment without affording the parties an opportunity to present, their addresses, is being held to be a breach of fair hearing. Now, for emphasis, we reproduced, in slide number 7. Sorry, the young man who is helping me with the slides. On slide 7, we have the provisions of section 294(1), is reproduced there. And the provision says every court established under this Constitution shall deliver its decision in writing not later than 90 days after the conclusion of evidence and final addresses. This lends vent to those who argue specifically that where a party is not given a right to address the court, it has been denied a constitutional right to fair hearing, because the Constitution specifically mentions the fact that final addresses seem to mark the end of trial or before judgment is given. It's actually judgment that marks the end of trial. But as far as parties are concerned, as far as parties and their counsel are concerned, the role they play, the roles each of them is supposed to play, supposed to terminate at final addresses. So next slide, please. So now we look at formulation of issues for determination. Because if you're preparing an address, you must have an issue for determination. Even though the rules may not particularly make provision for how issues are formulated and all of that, as you have in the Court of Appeal rules or the Supreme Court rules. But usually to help a court, when you are delivering an address, a final address, there is the need for you to identify an issue for determination or identify issues for determination. Usually, for example, it is essential that every final address has an issue or issues for determination. That point we made. And then the issues are the questions. They are the questions that the party expects the court to provide an answer to. which will also help the court to provide an answer to and want the court to also agree with him. Believing that those questions, if they are answered in favor of the party who formulated this, of the party who is addressing the court, judgment will be given in his favor. So like we said, it is essential that every final address has an issue or issues for determination, which is the question that we want the court to determine. If they determine it in your favor, then almost always the decision is going to be in your favor. The final decision is going to be in your favor. At the level of the trial court, slide 9, please. At the level of the trial court, it is important to know that the issue for determination in a criminal case is almost common anywhere you go to. It's almost common because the question is always, has the defender, whether the prosecution has established, has proved the charge against the defendant beyond reasonable doubt. This is the general issue that comes in any law report that you see, that you find in any final address that is given. That does not mean that some issues will not come up, like evidential issues or issues as to admissibility of some documents, whether it was properly done or not. But usually once you have gone beyond that particular level and a particular document has been admitted or a particular exhibit has been admitted, it will not be easy for you to begin to deal with it in your final addresses anymore. You can only raise such issues at the appeal court because the decision of the trial court has been given on it. So generally, the common issue that you have is whether the prosecution has established the guilt of the defendant beyond reasonable doubt. That is according to the required standard set by the law. So we will now look at the essentials of the defendant's final addresses. What are those things that an address by the defendant supposed to look at? The focus of the defendant's submission is to show that the defendant is not guilty. Just as the focus of the prosecution's case or the prosecution's address is that the guilt of the defendant has been proved. Not only has it been proved, but has been proved to the required standard, i.e. beyond reasonable doubt. That is how the defendant's address is also supposed to focus, to show the court that the guilt of the defendant has not been established. And that is to try to cast as much doubts as possible on the evidence led by the prosecution. In doing this, we made some suggestions here that in doing this, remember that everything we have said here are all suggestions which counsel may want to look at depending on what he is dealing with. Every suggestion we have made here may not be important in respect of every defendant's address, but as much as possible, some of them can be useful. So in doing this, in trying to cast doubts, in order to cast clouds, darkness on the case of the prosecution, which they think they've eloquently established, defendant counsel may want to show any of the following. In other words, he can say that the alleged offense is not shown to have taken place. That's one thing, because the beginning of proving a case is to show that the offense you are charging the defendant for has been committed before you go into who committed the offense. If the defendant is able to show that the offense alleged to have been committed by the defendant, for which he is standing trial, was not committed in the first place, then the matter has not even started at all. If it is a murder case, for example, it is expected that the fact that the deceased died must be established. If it is not established that the deceased died, then any inquiry into who killed the deceased and whether it was intentional or accidental or premeditated will become idle questions. So the defendant will want to even show that the alleged offense was not even shown to have been committed in the first place. It's also possible that the defendant will also want to say that the defendant was not properly identified as the offender. You know, the question of identification, of identity is very important. Once the defendant is able to cast doubts on his identity, in other words, if the prosecution is not able, in the course of the evidence they led, to show clearly that the person identified as the culprit or the person standing trial is the culprit and that he's been properly identified, the case is likely to fail. Because the prosecution may well have proved that the offense has taken place. And then the second question as to who committed the offense will remain outstanding. And they have picked on the defendant. If the defendant can say, look at all the evidence that have been put together and says, look, there is no proper evidence of identification, he will be able to also tie his address around that as well, so that his his client can get off the hook. And in fact, the fact that the defendant was denied right to fair hearing can equally be raised in his final address. For example, if it is addressed that the defendant is given by himself, the fact that he was not given a right to counsel, or that, for example, he asked for adjournment so that he can get a counsel to defend him, and the judge refused that quote and unquote reasonable application for adjournment, he can raise it an issue in his own final address. If he was not hearing the proceedings of the court very well because he does not speak English and the language of the High Court in Nigeria is English, he could also raise that in his final, address to say, well, I don't understand the language of the court very well, and I inform the court as such. To that extent, some of the things that have been said, I don't hear well. The ones I heard, they don't implicate me one bit. Those are issues he can equally raise at the level of trial, even though these are better cases that will be raised when he's going on appeal. Because it will be like, oh, if the court may be giving the trial court has given one decision on one or two issues, and you're asking him to sit on appeal on his own, on his own judgment. But defendant, especially when the defendant is representing himself, when he's not defended by, he's not represented by counsel, he can as well raise this issue of the fact that he's denied the right to fair hearing because he's denied an opportunity to get a counsel for himself, or that he was also not given an interpreter, and so even the proceedings were not clear to him. Can raise that issue. And then, of course, defendant's counsel or the defendant himself can equally raise an issue that the evidence presented was insufficient. In other words, that it does not meet the required standard. And the required standard under Section 135 of the Evidence Act is that is proof beyond reasonable doubt. So the contention of the defendant usually is to say that the evidence led by the prosecution is insufficient to prove the case against the defendant. So that he would tend to show by also examining all the witnesses who testified, the pieces of evidence they have tendered, whether documentary or oral, circumstantial or even real. He will look at all of them to say, even if you put all of these pieces of evidence together, they are not sufficient to establish that not only that the offense was not committed, but even if it was committed, the defendant was not the one who committed that offense. It's also possible for the defendant to raise the issue of alibi, that it was not that his alibi was not considered. We know that the position of the law is that if you are going to rely on the defense of alibi, you must make a plea, of alibi from the very beginning. So if the defendant says, look, I said I was elsewhere, I notified the police. When they even came to my house to arrest me, I told them that I was not in that place. I was not even in that town at all on that day. And they never bothered to do the investigation. At the level of trial, he can still raise it at address, at the level of address, even before the matter goes on appeal. So this is an area too that the defendant's counsel, they want to also dance around in putting his final address together. And of course, in murder trial, for example, or homicide cases, for example, the fact that the act of the defendant was done in self-defense is also something that is worthy of considering. So depending on the kind of case that defendant counsel is dealing with, it's not impossible for him to raise the question of, of self-defense in the circumstance. And then, of course, notwithstanding the power of the prosecution to say, well, even the force you have used is not in consonance with even the threat you claim to be facing, which is the principle of proportionality of force that is being used when you say you want to repel an attack on you or a threat to your life or a threat to your property. That can also be something that the prosecution could raise, but for the defendant, he must also raise that issue that if it is important for him to raise the issue that what he did, the act he committed was done in self-defense. And then, of course, it's possible for him to say that he was compelled to commit the offense under duress or the threat to his life. So we'll look at the next slide, which is slide 12. It's also open to the defendant to also look at in his address the fact that the prosecution failed to prove the mental element of the offense, because the actus reus must be there, the mens rea must be there. So taking all the evidence together, it's possible for the defense counsel to say, look, yes, the offense was committed. The alleged offense was committed. In other words, is it killing? Yes, killing took place. The deceased died. Yes, it was the defendant that killed the deceased, but the mental element, i.e., the fact that the action of the defendant was not only intentional, it was premeditated, has to be shown. So if it is not done, they can equally say, it can also try to let the court know that is, that the mental element of the offense, that is the mens rea of the offense, has not been established. Taking everything into, taking the evidence that have been led, and as well as the testimonies of witnesses into account. And that is to say, just like we said when we're dealing with no case submission the other time, a defendant counsel must always keep his eye on the ball. While the evidence, while trial is going on, you must also be able to look at what everybody says and not just say, no, whatever, I'll look at the record of proceedings now and prepare my address from it. Look at it. Even look at the witnesses intently to see to what extent what they are saying seem to make sense in the first place. And then at whatever point any document is being tendered or any evidence is being tendered, we need to also look at it more carefully. So the fact that the prosecution failed to prove the mental element of the offense is something that the defense counsel will hold on very, very tightly to see if he could get his client off the hook. He can also, in his final address, raise the issue of illegal search and seizure. In other words, the search of his house was illegal. Yes, Sadao and the state are against Litam are all to the effect that no matter how illegal a search is, any evidence that is obtained from there is admissible. In fact, in our against Litam, his lordship has mentioned the fact that even if the evidence was stolen, it will still be admissible. The provision of the Evidence Act of Section 14, which also says they should also look at the reasonability, of what was used in obtaining a piece of evidence during a search will also be looked at. So, defense counsel can equally decide to also call in aid the provisions of Section 14 to show, that the illegal search and the illegal seizure or the kind of force that was used to obtain the piece of evidence that is now being relied upon, is not such as the court should rely on. One of the things that can work against the defendant, which can only one of it can, it alone can let the defendant go to jail or go to the gallows, is confessional statement. A defendant counsel can also raise the issue that yes, a confessional statement was tendered. We raised objection, or even where he did not raise objection, we did not raise objection. It was admitted by the court. It does not stop a counsel to raise issue out of it in his final address. He can seek to say that even though that statement was admitted in evidence, it carries no reasonable weight. In other words, the court should not attach any weight to it because the mere fact that a confessional statement has been admitted in evidence does not mean that the court must act on it hook, line, and sinker. In fact, there are authorities to the effect that even when a confessional statement has been admitted, the court to give weight to it, to be able to act properly on it, it should ask itself some few questions. One is whether is there anything outside the confession to show that the confession is true? Two, is the statement corroborated? It doesn't mean that if confessional statement is not corroborated, it cannot be acted upon. But these are all suggestions that the court has made, that the higher courts have made, that the trial court should consider when it's going to deliver its judgment, even when he already has a confessional statement that has been admitted. And number three, is the statement of facts made in the confession, so far as can be tested, can it be said to be true? So far as it can be tested, is it true? Four, does the defendant have the opportunity to commit the offense alleged, the offense charged, for which he was tried? Five, was the confession possible? Is it possible to make that confession? And then finally, is the confession consistent with other facts which have been proved at the trial? For this, we might see the case of Alo, L-O-A-L-O, as well, Alo against the state, which is, citation is also here. And we may also want to also look at the case of Mocha and against the state as well. So it's not the case that once a confessional statement has been made, counsel should go home and say, well, since the man has committed to committing the offense, there's nothing we can do again. Because even if he made a confession, counsel can still go around to say, look, the court should still look at other evidence, whether they lend credence to the confessional statement that has been made. If a confessional statement stands alone, the court should be wary in acting on it. I'm sure we remember, I don't know whether we remember, some years ago, I can't remember which year exactly again, when something happened in Lagos, when one man who was about 50-something years old claimed to have impregnated a young girl of 12 or 13 years. Who have been saying that the man is alleged. I don't know, are we together, please? Mr. Chairman, can you hear me, sir?
Yes, sir.
I can hear you.
Oh, okay. So I was referring to one case that happened in Lagos some years ago, when one man was alleged not to have to be suffering from primary impotency, i.e., that he doesn't have a third leg, he doesn't have a rise in his penis. And so one time somebody came up with an allegation that he raped his daughter and the daughter is pregnant for him. In the man's statement to the police, he admitted that he did the thing, when in actual fact, he doesn't have a rise at all in his third leg. As time was moving, even when NGOs went into the matter, 4 or 5 months came by, the tummy did not increase. It was later discovered that it was a fraud committed by the father of the girl on the man. In Africa, how it is, when they say a man is suffering from primary impotency, in other words, his penis cannot rise, the shame is much. So the man agreed fast that he was the owner, he was the one who was responsible for the pregnancy, he was responsible for rape, he was ready to go to jail for having committed rape, when in actual fact, he never committed any rape. So it's very possible for a counsel to still raise issues even when a confessional statement is facing him directly in the court. And then, of course, the prosecution, the defendant can also try to show that the prosecution witnesses' accounts, as many of them has testified, that they are quite inconsistent, that they are contradictory, and urging the court not to rely on it. So please, we're on slide 13. Then, of course, he can also challenge the credibility of prosecution witnesses, challenge the credibility of prosecution witnesses, trying to show that they are not witnesses of truth. The court should not believe them. That is also part of what counsel can do. And that means that he must have watched the proceedings properly, also seen the demeanor of such a witness, just the same way the judge is watching the demeanor of witnesses. He too should they should also watch the demeanor of every witness that comes to testify, and then try to bring out any inconsistency, any contradiction, anything that does not flow or does not add up in their cases in the course of his final address. Then, of course, he will also, his job is to present reasonable doubt. In other words, he should present a theory of innocence. In other words, in yet other words, he has to show that the case as presented by the prosecution is not well made out. I mean, to justify convicting the defendant. In other words, he will cast doubt on the case of the prosecution by saying, no, what PW1 said is against what PW2 said cannot be true, or that the fact that even the fact that PW2 contradicted PW3, I mean, cast a lot of doubt into, on the case of the prosecution. The fact that one of the witnesses, the star witnesses, testified so lucidly during examination in chief, and that when it was time for cross-examination, he began to suffer from some form of selective memory loss, or that some of the witnesses who testified were suffering some kind of conspiratorial loss of memory. All of these are the things that a defense counsel is supposed to bring out to cast doubt on what the prosecution has done. And then, of course, he is supposed to appeal to the judge's sense of justice, fairness, and empathy. All these in his addresses. The concluding part of the address should leave a lasting impression, to leave the judge saying, I don't think from all of these pieces of evidence, the contradictions we have, the inconsistencies we have, some of the things that do not seem to add up here, don't know how safe it is to convict the defendant in this circumstance. The moment that doubt is created in the mind of the judge, your client has won the day. So, and then of course, every defendant's address, defendant's final address must end with a call to acquit the defendant. It will say that having said all of this, having considered all of what the parties have said and the inconsistencies and the authorities that have been cited, there must always be that call to say that the defendant should not only be discharged, but should be acquitted of the offense with which he was charged, or for which he is charged. So we'll look at the next slide, which is slide 14. And we'll look at the essentials of the prosecution's final address. On the side of the prosecution, what is expected of him? The burden that the prosecution bears when dealing in a criminal matter is no mean task at all. It's a heavy one. The defendant is entitled to come and sit down because the Constitution says he has a presumption of innocence. The Constitution also says in section 36 sub 11 that he has a right to remain silent. So he can actually come while the proceeding is going on. He can decide to be sleeping spiritually. Sleeping not like he will just come and close his eyes so that it will not be like contempt of court. But he can just be there, but not even doing anything and not say anything. So the job is actually on the prosecution, it's on the prosecution. As the section 36(5) says that the accused person is held to be, is presumed innocent until his guilt is established. It is the prosecution that is going to do the job of establishing that guilt. And section 135 of the Evidence Act also says that proof in criminal cases is beyond reasonable doubt. That goes to say that the burden on the prosecution is actually a huge one. And so after he has done all his work in his own address, his final addresses, the prosecution is supposed to pay attention to all details. For example, some of the suggestions we have here is that he's expected, of course, to summarize the evidence, meaning that he has to highlight his strong points. He has to establish a strong point, highlight the strong points in the prosecution's case, all tending to show that the offense could not have been committed by any other person but the defendant. That is what is expected to do. He must establish a compelling narrative presenting the case in a logical and convincing manner. as to how the offense was committed, the facts as presented by the prosecution must be such that they are weavable. They are able, you can look at them together to say they should make a chain that will not even separate, that will not disintegrate. It should be able to tell a story as to how A did this before this happened, what A witnessed the defendant do, what B witnessed the defendant do at point B, and all of that. The thing must add up. The story must be made to be as logical as possible. It must make sense. It must be in a convincing, the narrative must be so compelling such that even when the judge is listening, he should be able to say, oh yes, I think that is how it is. So if PW1 testified on the first and PW5 testified on the second, all of this, it is the job of the prosecuting counsel to show how the evidence of PW5 and that of PW1 tally very well as to form one compelling account, one compelling narrative that anybody listening to it will say, okay, yes, so this is how the offense could have taken place. So the next slide, please. That means next slide, which is slide 15, the young man helping me. So the prosecution is expected to address the elements of the offense and show how evidence presented satisfies each element. It must establish that all the elements, these are the ingredients of the offense. In the offense of murder, for example, it must establish that the deceased died and that it was the act of the defendant that caused the death of the deceased, and that the act was intentional, i.e., that he intended to either kill the deceased or he wanted to cause a grievous bodily hurt. That is what is expected to show. So he has to lead evidence to, he has to also show, his address has to also show how PW1, what PW1 said as to the act of the defendant before, during, and after the murder, for example, to show that the action was not accidental, that it was not a mistaken act, but that it was premeditated, it was intentional. So he must address, so counsel must address each element of the offense and show how the evidence that have been presented in the course of the trial have proved each of the elements that he has identified. That he was supposed to show. Then, of course, since we say that the identity of the defendant is important, it is expected that he must hammer on the issue of identity, that the defendant and no other person was the one who committed the offense. He must show evidence, must show from the evidence that have been led so far, who or what identifies the defendant as the offender in the case. Like we mentioned before, the defendant, the prosecution must also show from the evidence that have been put together, either oral, documentary, real, or circumstantial, he must show that the act of the defendant was intentional and premeditated. We continue to make emphasize this point of intentional premeditation and all of that because of the issue of mens rea. Once it is shown that the act was by mistake, that it was an act that was done accidentally, that it was an act that was done when the mind was not at work, either because the man was insane or he was in a drunken stupor or any of those things, it could rob the offense of its mental element. And if that mental element is robbed of the offense, then of course, the defendant is going to go away free or perhaps take a very light sentence because the mental element of the offense is taken away. So in murder trials before, like we said, we try to mention if in murder trial, the causal link must never break. The evidence that the prosecution witnesses led, must also be tied up. Counsel must try to see, to tie up how the act of the defendant resulted in the death of the deceased. All the witnesses who testified, how those things add up must also come, because once there is a break in that chain, it becomes the defendant can always go away a free man. So this evidence we're talking about, the linking up we're talking about, it's not like the prosecution witness is going to, prosecution counsel is going to manufacture any evidence at this point. His job is to sift all the evidence, the pieces of evidence that have been put together in the course of trial, to let the court see it, from his own perspective, that the prosecution has actually done a good job and that it has proved, has proved the guilt of the defendant beyond reasonable doubt as required by the law. Where possible, even though motive is not a requirement of the law to prove, for example, in a murder charge, where motive is possible to prove it. If it is shown that, because they had a quarrel before over a girlfriend, and that was what he said, that was what the defendant said. This is what the defendant said before the killing of the deceased. This is what he said when he was killing the deceased, or even the circumstances could be such that there was motive that the defendant could have killed the deceased. Where it is possible to establish motive, prosecution must not shy away from showing motive, even though it is not a requirement of the law in proving, improving a murder case. So motive for concealment or cover-up is possible to prosecution. Witnesses should be able to establish that, and counsel should also not shy away from tying up all of those, those knots to show that the defendant cannot escape. And then, of course, where expert evidence is required, it is the job of the prosecution to do so. So once expert evidence was tendered and duly admitted in the course of the trial, in the course of the address of counsel, he must also make reference to it to show that the thing was, was properly done, and how the expert came to testify. If there was expert, anything that was tendered, any document that was tendered by an expert, or any item or result of test that was tendered, the prosecution witness must, in his final address, make reference to them to let the court see it from the prosecution's perspective, that the case of the prosecution was duly proved against the defendant. In fact, if the defendant intends to put up a self-defense, which will be obvious, from the evidence that is being led, he must try to disprove a self-defense or other justifications that may be available to the defendant by showing that from what has happened, from the testimony of PW1, PW2, PW3, even perhaps PW5, who is a relation of the defendant himself, it's not possible to say that what has happened is, is done in self-defense. Okay, then look at the kind of force that was used. It doesn't really portend, someone who was acting in self-defense, but someone who actually was out to spill blood. And if it is a mistake or accident that they want to claim, evidence that has been led by the prosecution to lay all of those to rest must be highlighted by the prosecution witness in his closing address. Then, of course, alibi, which, of course, defendants usually rely on all the time. It's the job of the prosecution to ensure that that end is really tied up. The fact that defense of alibi was not raised timeously to let the prosecution witness or let the police go to investigate is something that he could equally raise. The fact that it was being raised for the first time at the trial, if that's the case, counsel must make reference to it in his address. And the fact that even though he raised alibi, but the alibi was not properly raised because the details of where he was, the defendant claimed to have been on the date of the incident, if he didn't provide those details, prosecution should also hold that there was no, should also argue that there was no way the prosecution would have gone to investigate that alibi. As to do that would mean embarking on a wild goose chase. All this he must show. So on the whole, the prosecution witness is expected to prove the defendant's guilt beyond reasonable doubt. And in doing so, what we say for the defendant, we say for the prosecution, he must always keep his eye on the ball every time. He has to look at what is, is going on, what each witness is saying, so that he would be in a position to really make a compelling account of what happened, so that the story of the prosecution that the defendant was the one who committed the offense would be compelling, would be logical enough, would be something that the court will look at and say, no other person apart from the defendant would have committed this offense. So we then, of course, we as like 17, which is the essentials of the defendant's reply address, where the reply address is not particularly, it's not compulsory, it's not all the time necessary. This is an address that is simply to reply to points of law raised in the prosecution's address. It is not an additional address to add to or to review the main address. So it's just supposed to answer issues that has been raised by the other party, legal issues that have been raised by the other party, so that the rule of fair hearing would properly be said to have been adhered to. So he will be allowed to reply to the defendants, to the prosecution's any issue that has been raised like that. So that essentially is what it is. So it's not supposed to now begin to look for new pieces of evidence to begin to introduce, no, or begin to look for new laws that he forgot to cite in the course of his main address to begin to come and cite them. Definitely not that. And of course, by the provisions of section 304, 269, sub 2 of the ACGL, it's supposed to be written, address is supposed to be, final address is supposed to be written. That is ACGL of Lagos. The ACGL doesn't seem to be very express in terms of whether it must be a written address. But of course, in all the courts that I also have visited in recent time, all addresses are usually written, even in ACJ jurisdictions. So after the close of evidence and written addresses have been filed, usually a date is fixed for adoption of written addresses. And then, of course, on that day, a party will inform the court, my lord, we have filed our written address in compliance with the rules of this court. We wish to humbly adopt same as our oral argument before this court. The rules that we are referring to here, must be understood with the greatest respect to be rules of the High Court as far as civil rules may be concerned, because even the ACGL does not seem to make provision as to how the written address should look like and all of that. But it's assumed that the rules of a written address as it operates in civil is the same way that it will operate in criminal, unless the court gives a further directive. Please, 19, slide 19, please. So, and the rules seem to have been, even though the rules we are mentioning here are rules of civil procedure, yeah, I think that in criminal proceedings, where written addresses are also being presented, all the rules here also seem to apply. And where any party fails to appear in court, the written address shall be taken as having been adopted. Once you have filed your own written address, and on the day of the hearing or the date that we're supposed to adopt those addresses, you do not, turn up to court. In court, it will be, it is deemed that you have adopted sin. And of course, that we find in order 31 rule 4 of the Lagos rules and order 33 rule 4 of the Abuja rules. In all cases, 2 copies of the written address shall be filed in court, while all copies to the case, all parties to the case must be served. We see that in order 31 rule 5 Lagos, in order 36 rule 7 of the Abuja rules as well. That's for written, for written address. So look at the next slide, which is slide 20 again. An oral argument. In addition to the written address, where written addresses have been filed, a party is also entitled to some minutes, usually 20 minutes, not more than 20 minutes, to elaborate on the written address. It is just meant to emphasize, because it's if you come to court, you are going to adopt. You're actually going to adopt your written address. Once it has been adopted, it is meant to It is to emphasize, to clarify the written brief, to emphasize the written brief, to clarify the written brief. It's not an opportunity to begin to argue new points that are not contained in the written address. And if what you have, you want to say is already in the written address, then you don't necessarily have to go into reading them or presenting them as new legal issues you are raising the point. So we have made the point that in addition to the written address, a party is expected or is given some time to make an oral submission in adumbration, in clarification, in clarification and in emphasis of the written brief. So we made reference to the 33 Rule 4 of Abuja rules and the 35 Rule 41 of the Lagos rules. That is not to say that if there are practice directions in some states or even in the Federal High Court or anywhere that deals with rules on written addresses or final addresses in the High Court, which I probably have not seen, you can also draw our attention to it. But I know that, in fact, the way it is done in civil is also the same way that is done in criminal. So we look at the last, next slide, which is slide 21. Slide 21 and 22 basically be looking at ethical issues. And one of the ethical issues that arises in the course of final addresses, because ordinarily, very often, we see lawyers trying to grandstand when they are in court and making final addresses or to adopt their final written addresses and saying things that are not correct. Some things that they know are not correct, they do say it. Points, even evidence that was not led in their written or in their final addresses, they make reference to the fact that such evidence was led. Evidence that was led, they will even tell you, look, my lord, through the whole gamut of the testimony of PW5 to PW10 or to PW50, no point was raised in respect of this link or that link or that link, even when in black and white, the thing is evident, so that maybe those sitting in court will praise them. So the rules of professional conduct have also set some limitations. There is a duty not to mislead the court. Of course, Rule 32, sub Rule 2 of the RPC says that it is duty to disclose adverse legal authority in the jurisdiction, even if it's not cited by the opposing counsel. In other words, counsel is also expected, if there is something, if there is an authority that he knows, a legal authority that he knows that does not really, that is not in his own interest, he should also draw the attention of the court to it, even if the opposing counsel does not do so. And I think I probably will ask Oga Docs and some few other lawyers, crack litigation lawyers here, how many of them have ever done that? You see an authority that does not support your case at all, and then you say you bring the attention of the other person to it or draw the attention of the court to it. I don't know how many of us have done that before, but the rule says we should all do that. I don't think that the drafters of the rule actually expect that anybody is going to really obey that rule with any seriousness, but that's just my own opinion. Then, of course, the rules also provide that we're not supposed to knowingly misquote the content of any paper, and that was the one I was trying to talk about before. Not to misquote the content of any paper, the testimony of a witness, language of the argument of the opposing party, decision or a textbook. Nobody should knowingly misquote anything. What is not in the document, don't say it is there. What is there, don't misquote it. Don't say, just to grandstand. Thank God written address has come to help us. When it was oral addresses that we were giving fully that time, you see lawyers that will just face, instead of facing the court, they will face the gallery and begin to argue. My lord, the whole case, what the prosecution has filed is a worthless piece of paper. There is no piece of evidence has been laid, even when there is an armada of evidence. that is already before the court, but he will still be arguing like that and shouting on top of his voice. So that too, the rules of professional conduct make provision for. Now, of course, the rules also provide that you should not cite any decision which you know has been overruled or a law that has already been repealed with intent to mislead the court. That is also an obligation that we all need to also abide by. And then, of course, finally, not to assert an argument as a fact, that which has not been proved, or to conceal in an opening statement, fact upon which he intends to rely. And that is where we use the opening statement, which we don't often use here like that. So basically, that is all. That's the thought I have to share with us this evening. And I want to thank you all for listening. Thank you for your patience, for tolerating me up to this point. I'm also sorry that I think I've exceeded our time by about 50 minutes already. Thank you very much, Mr. Chairman. Thank you, all the participants here. And God bless you all.
Thank you very much, Dr. James Agaba. Your presentation, as usual, was very, very detailed, well researched, and we can't thank you enough for giving of yourself. But Doc, before you go, there are a few questions for you, and I'll quickly go straight into them so that we can move on to the next stage, sir.
Okay.
Now,
you may also want to take, sorry, sir, sorry, Mr. Mayo, you may want to also take some interventions from our colleagues who are in the house too, from the panelists who are there. I think some panelists are still here. Me too, I'm also ready to learn. I like the interventions, but if they are around.
Yeah, I can see that Mr. Onyeke is here. So
Okay.
hopefully he would also take some of the questions.
Uh-huh.
So a colleague of ours, his name is Mr. Kaudi Ade Muagun. He would like to know, sir, can an IPO who has retired before the defendant is charged be called to give evidence in such a case? So in an instance where an IPO has retired before the case that he investigated is charged, can he validly give evidence in such a case? This is from Mr. Kaudi Ade Muagun.
Okay. Okay. Can you hear me?
We can hear you, sir.
Okay. If you ask me, I don't think he can. If he must, not in the capacity of an IPO. If it is something that he saw in his own capacity as a human being, given the fact that the evidence access is a competent witness and also a compellable witness, if he has the required intelligence, and he knows also the importance of telling the truth, maybe in his capacity as a person, in which case, when he's presented by the prosecution to give evidence like that, he will be properly cross-examined. In what capacity is he there? If he's coming in his capacity as IPO, I do not think that he has that capacity to be there, because the moment he retires from the police, then he doesn't have the bias of coming to represent the police in a particular case. That is actually my take. I don't think he's actually competent to do so. And if he's coming as an ordinary person, as a competent person under Section 175 of the Evidence Act, yes, why not? It will come. But I think cross-examination will also put him where he's supposed to be.
Thank you very much, Doctor. This is another question. Somebody would like to know if counsel is of the view that a piece of evidence is wrongfully admitted and the court overrules him on his objection, can counsel raise that issue again in his final address, or is he bound to only file an appeal at that point?
Yeah, of course. Once if a piece of evidence is tendered, objection has been taken, your objection has been overruled. The court has declared that the piece of evidence is not only relevant, but that it is admissible, and it goes ahead and admits it. You cannot now in your final address raise it. Even if you raise it, you're raising it just for the fun of it, just to keep your mind around that particular piece of evidence when you're drafting your grounds of appeal. Because the court cannot give one ruling now, and then in the final judgment, it now gives another ruling. Is he going to admit what he has rejected? So I don't think that makes sense. Addressing the court on it again will not, it's not something that will be done. On the other hand, because I don't know whether maybe the person also may want, lawyers now, these young ones actually, they like putting us on the spot. Maybe because I said that if a confessional statement has been admitted in evidence, we could say that it's a closed matter. I said that in your final address, you can make reference to it because the law seems to make some exceptions. To say that even if where there is a confessional statement, for the court to act on it, it should consider other pieces of evidence, whether that confessional statement does not stand alone. And in doing so too, I also, after citing the case of Aloe against the state and the Nkwacha against the state, I also gave the story of what happened in Lagos about that man that was impotent. It is very possible that someone can make an admission or make a confession that is not true. Ordinarily, a confession is supposed to be true. A confession is supposed to be true. The fact that it's a confession means it is true, is it not so? But in some cases, it may not be true. In the case of that man, he was suffering from mental instability, a sort of depression, if you ask me. Because if the community in which he lives has this feeling that he is not a man, Africa, how we look at this problem of a man either not being able to sleep with a woman or not being able to raise the child, the way we look at it in Africa is such that somebody can even say, oh, did they say I impregnated this girl? I agree now. At least my community people will know that I'm not impotent as they said I was. For me, I think that is a mental case actually. But if you do not know, and since the man doesn't present with anything look like was mentally unstable, somebody can believe it, and then assuming that matter had gone to trial, that confessional statement must have been admitted. But the advice the court has given is that, look, apart from this confessional statement, please look at other issues. Is that confession, given all the circumstances, is it likely that it can be true? In other words, when the police made investigations and they decided to go deep into it, after they discovered that the man was impotent, primary impotence, is it possible for him to have committed rape before 2011? Because in 2011, the criminal law of Lagos came into being and then criminalized wrongful touching, committing a rape by fingering, by using an object. But pre-2011, anywhere around the country, the offense of rape was penal. It's only penal vagina. So if any man who is clinically certified to be impotent, primarily, is it possible for you to convict him of rape? Definitely, it would be wrong. So I think that is the angle that I think that's the angle from which the court in Aloe, Nkwacha, and a couple of other cases try to look at it. That it is that even when a confessional statement has been admitted, court should also look at it very well before acting on it. It is one thing for you to admit a piece of evidence. If it is another thing for you to give weight to it, and what weight to give to it. So our advice is that even when this confessional statement has been admitted, the court should attach minimal weight to it. So back to the question, you cannot raise objection you cannot say that piece of evidence that has been admitted should not be admitted, but you can argue that the court should should attach no weight to it, or that should attach little weight to it, which if the court does, by attaching little weight to it, perhaps the weight attached to it may not be enough to pull through this to satisfy the requirement of the standard of proof. I don't know whether
Yeah, Doc, that was brilliant. My mindset was that, the court is basically functus at that point. And once you raise that issue again, you want to put the court in a position where it reverses itself. But you've explained it that the best way to go about it is to attack it from a different point of view and ask that court reduces the probative value. So you actually did shed good light on it. Thank you very much, Doc. Now, this is a very funny question. Doc, it looks like you addressed in the course of your presentation defenses to assault. Probably you addressed it from the angle of self-defense. One of our colleagues wants to know that in criminal parlance, is there anything that is recognized as true fighting as a defense to assault in to a charge of assault. That can you raise the defense of true fighting? I don't know where that person found that from. I haven't come across that kind of thing before. I wanted you to respond to it, sir.
Okay, I also don't I don't know of the defense of true fighting, but I know that there could always be sudden fight. There could be sudden fight where nobody really knew. In fact, people are just walking. It can be you are walking in Lagos in where I would say Tinubu. Okay, it's Tinubu Square. Okay, either Tinubu Square or that place, Mandilas. You are walking along that street to go and buy your tie or your suit or something, and I'm walking along that street. No premeditation. You don't know me before. I don't know you before. We are all just walking. You are looking at what you want to buy. I'm looking at what I want to buy. You're looking to the left. I'm looking to the right. But we are coming from different directions. Then we collided. You know, it's a mini. If it were two cars, that would have been a clear case of accident, isn't it? But these are two human beings that just hit themselves. So if we hit each other like that, and we do not say sorry to each other, you know, fight can take off from there. Is it not so? So if there is a sudden fight like that, that was not premeditated, the question of self-defense could still come in. If both of you never had anything in your hand, I just said, why did you hit me? Why don't you used to look? You uncle, you know they look, you decrease, and then I slap the person, and the person decided now to carry hammer from the ground and break my head. Will he say that the hammer he used on my head that broke my head and killed me, that he did it in self-defense? Then the question of proportionality will come in. The force he used, is it proportional to my assault? Agreed that we collided when we're walking on a tiny road. I mean, trying to get something in Mandilas. When we just, so to say, had that accident. I was the first person to slap because he hit me very hard when that collision took place. One would expect that the next thing too would have been he too would hit me. Or if he was having a bag in his hand, he could use that bag to hit me. But if he picked a hammer, he looked for a hammer, and then finally put paid to my existence, will he say that he's in self-defense? I doubt much. So back to his question, I don't think that sudden fight or two fighting is a defense per se. What happens is after two persons fight, what happened? What offense was committed from there? The only thing will be, and if it is an offense, not even a defense, but if it's an offense, it will be like, oh, both of you are disturbing public peace or something like that. So two fighting, I don't think it's a defense per se. But in the defense of assault, one can say, oh yes, I slapped him because we suddenly fought. So maybe something like that. That's just what can be said. Yeah.
Yeah, thank you very much, Doc. This question is from a young lawyer. He wants you to provide advice on how soon a young we can embark on or take on criminal trials. What's your advice? Basically, he wants to know whether it's advisable for young weeks to take on criminal trials, and how soon can they take it on in their career?
No, actually, once you're called to bar, you have become a lawyer, and you can do anything that a lawyer can do. I think he has conscience. That's why he's asking this question. Like, oh, it is the liberty or the life of someone else that is at stake here. I mean, is it possible for me to just start coming up like immediately and take up criminal cases, which if I don't handle well, my client in a very bad case, maybe that's how he's feeling like that. But generally speaking, there is no set time for a lawyer to take up any case whatsoever. Or even criminal cases, you can take any case at all. But then, of course, you can't take the place of experience. The right thing to do as a young lawyer is to follow a senior You don't need to work with a particular senior to go to even follow him to court. You can ask him, sir, you have a criminal matter that I'm interested in, can I follow you? Of course, he will oblige you. Apart from that, you can as well, on your own, even as a young lawyer, decide to go to court and watch proceedings, because there's publicity of trial as a constitutional right. So you can go there and watch what lawyers do. So even when after you have watched proceedings, after you finish your own case every day, you go back to the criminal court. If that is an area you want to make a career, you can actually go look at what they are doing. After watching for some time and with some level of consistency, you discover that even in 3 years, you can take up some serious matters and you grow on it. You can't wait and say, no, I must be 10 or I must be 15 before I take up a criminal matter, because the fact that you're 15 at the bar does not necessarily mean that if you take up a criminal matter, you will do well in it. It depends on what energy you put into it and perhaps the evidence that's available to you. And again, who is on the other side? I don't know whether that answers his question.
Yeah, it does, Doc, it does. Thank you very much for that. Now, one of our colleagues would like to know whether all final addresses must follow the IRAC pattern.
What?
One of our colleagues wants to know whether all final addresses in criminal matters must follow the IRAC pattern.
Okay. When you say IRAC pattern, what do you mean?
She's defined it as IRAC. I thought that this was something that flowed from your presentation. Issues arising therefrom. She didn't specify. She just used the word IRAC pattern. IRAC.
Okay. Well, I don't know. These young people, they have a way of producing their own producing what they put there to help them in understanding. I may not understand. I may not understand how they put it, but I do know that yes, usually your address will normally, of course, it will follow a pattern. It will normally have an introduction. What is the case about? And it must also have issues for determination. What are the resolution of the issues? How do you try to resolve each of the issues? In which case you will have to now cite authorities, cite legal authorities, cite cases, cite sections of laws to resolve each of the issues, and then go on until at the end of the day, you will be asking the court to is a hierarchy. It puts it issues, resolution, and what I don't know what the acronym is. Acronym is something that you can put that to use on your own to just follow the pattern. To understand that, if I get this, I think this is how I will understand this thing. We may not have followed the same pattern, but of course it must flow. Must have an intro. Must have the introduction. Of course, must have the issues that you have for resolution, the issues for determination. Remember the facts of the case is also possible depending on how you want. Some people, when they put the introduction, they will also have the facts embedded in that introduction as to what led us to the address. So it's also possible for you to introduce the address and still put the facts of the case there before you look at issues for resolution. It's also possible to use the introductory paragraph to also put the facts that you're going to be dealing with all together there in that paragraph, and still go ahead to identify the issues. Whichever format you follow, what the court look at more is usually when it is an address, what they look at is what are the issues you have raised and how have you tried to resolve them. The way you resolve it, the court may not necessarily follow you to resolve them, but it is expected that you must attempt to resolve them. You say it favors your case. That you say it favors your case may not necessarily mean that it will favor you in the final resolution by the court, but you must bring your own suggestions. your own, resolution, your own answers, your own solution, your own opinion, to the issues you have raised, to how the court should decide it.
Yeah, thank you very much, Doctor.
Yeah, thank you.
Yeah, yes, you have the floor, Mrs. Eke.
Yes. Good evening, all. I just want to say, since we're talking about criminal proceedings, criminal trials, I think it's important, like the speaker said previously, keep your eye on the ball. It's nice to have acronyms and things you've learned, perhaps in the classroom, bringing them out there, beautiful. But the important thing is, does this serve your purpose? What exactly are you trying to establish? What are you trying to achieve? I can tell you that the ingredients of the offense, proving the ingredients of the particular offense of the charge, is very critical. So I'll say, if you are filing a final address, for instance, as a prosecution, first, of course, you have to bring up the facts, and then you have to bring out the charge. What does the law say? What are the ingredients of that particular charge, of that offense that you are expected to prove? When you have that, the authorities are bound to the effect that once you are able to prove the ingredients of a charge, it's taken that you have established that case. So your eyes on the ball, your eyes on the ingredients of the offense. Then you can now support it with a fact. What evidence have you led to support to establish this fact? And then for the defense, what you're saying is, look, these are the ingredients of the offense. The prosecution has not proved any of them at all. So let's try not to be bound, by a lot of theories, but rather identify the principal things that you need to establish the case, or you need, to disprove that case, as it were. That's just an advice I want to give. Thank you.
Thank you very much, Ms. Cordelia.
Thank you very much, Mr. Eke. I don't know whether Mr. Eke is there. Mr. Eke, do you have any comments on any of the questions that have been asked from your own perspective and experience over time?
Good afternoon, everybody. Let me first of all, once again, apologize for coming in late. I had to rush to do one or two things. I had the privilege of reading the presentation of Dr. Agaba, and before he presented it, and I did mention to him that it was going to be a very, very interesting and didactic session for those who will tune in today. So once again, my deepest appreciation to him for his ability to make this whole thing very simple and very, very revealing for our audience. I just want to mention one or two things. Ms. Zeki has really dealt with the other issue that I wanted to expand on. One of the issues I wanted to comment on has to do with wrongfully admitted evidence. I know it was a question that came along those lines. A court that has admitted wrongfully a piece of evidence in the course of a trial can review its decision at the end of the day with respect to that piece of evidence if it comes to the conclusion that the evidence or the piece of evidence is inadmissible. It can, in the course of writing its judgment, review its position. I think that is the position of the law, unless I'm mistaken. This does not mean that the court is sitting on appeal over its own decision. It's simply one of the powers that the judge has in having heard the totality of evidence to come to a conclusion that that piece of evidence was wrongfully admitted. And obviously, a party who is not satisfied at the point where it was admitted and who feels it was wrongfully admitted can seek to have it overturned, that decision overturned on appeal. That's an option outside reiterating it in the final address. The court can show more to review its position on that and say, oh, that was wrongfully admitted, that's not the law, and review it. The court is not too sufficient, so to speak, on that piece of evidence because trial has not been concluded so to speak. Just wanted to put that out. Then, with respect to the presentation of final address, you see, the writing and the presentation of the final address it's an art. It's an art in the sense that one of the things I've seen that is missing in recent times in the way we present our case as lawyers is the use of English. A lot of lawyers now have not really paid attention or did not really pay attention to some of the English courses in university with respect to how to present a coherent address that flows on topic sentences, using of paragraphs, and orderliness in their thought process, such that you see the kind of addresses that when the counsel on the other side serves it on you, you read it, it appears as if it has not gone through some editing process. Maybe because of in recent times, the use of abbreviations in spellings has caused a lot of written addresses now to fall under what I would call poor comprehension skills by lawyers. You see the use of words like you want to say lose something as in the LOSE, people use LOOSE, which is to free something, which is different from losing something as something is lost. You see the words like sometimes in April. There's no, I mean, that I've always known the word to be sometime in, but nowadays it's beginning to look as if it's an acceptable English to use such words. There are so many not knowing how to use the word BEEN and BEING. These are some of the things that make the written address in terms of the English language to be poorly presented. But when we go to the meat of the matter, we are lawyers at the end of the day, we are not English students. But English is the source with which we do, is the tool with which we do our work as lawyers. So it's important that we improve ourselves in that regard. For me, Doctor captured it as the essence of it. Grandstanding is not the way to win cases through written address. Written address is supposed to be a concise presentation of your case, why the court should grant you judgment, and why the party, if you are the defender, why the other party has not done enough to get judgment against you. If you have a counterclaim, why your counterclaim should succeed. If it's a criminal matter, why the prosecution should not succeed, and why the defendant should be discharged and acquitted. Now, there must be an orderly process from when you present the facts as adduced by prosecution, the evidence led, the attempt to controvert those evidence, if the defense was able to give his own evidence, what he did, and you summarize them and bring them, supporting them with relevant positions of the law and cases and case law, so that it's like an interesting novel coming from the very top up to the point where you can give your concluding thoughts. For me, I have a very serious problem with where lawyers don't follow this process that is orderly and coherent. You just see that the point you try to make to the court get lost in all this rigmarole of not knowing how to marshal your thoughts. So the first order of business is that lawyers should learn seriously to appreciate the role of English language, the use of English, and the application of proper English in final addresses. It is key. It is the only way you can present. In fact, you can present a bad case in good English, such that at a point the court will be sympathetic towards you. Though, of course, the law is the law, we all know it. The court may be sympathetic towards you, knowing that yes, you did try. The only way the court can probably reward you is not to say that the lawyer substituted his address for, of course, we know that is not possible for evidence, but to maybe where you are supposed to, your client is supposed to probably get a very harsh punishment, where there's a discretion that the court can exercise it in your favor because of the way you presented your case and the way you presented your thing. It made it interesting reading for the court. So we cannot underscore the importance of English. I would advise our colleagues who have challenges with how to write long essays to please open themselves up to trainings that will help them and assist them so that the thoughts that they have, which are of the positions of the law, can be clearly and adequately and coherently presented to the court for the court to be able to see their case in a very, very good manner. I think that's just all I want to put out there now, because the presentation of the case at the point where trial has concluded is entirely the ability of the lawyer to use English in his thought process, to properly use English to present that case. And I think that is something that we should all try to master as we practice approach. And I wish you all the very best. Thank you very much.
Thank you. We're not going to leave you just yet. There are a few questions here that I would like to pass on to you. A colleague of ours called Al Qasim from Kano wants to know whether the court has the powers to close the defense right to address the court. And at what point does the court exercise that kind of power?
Okay, I think we must put it in proper perspective. The right to file a final address are embedded in the rules of either criminal or civil rules of courts. You have days allotted to each party to file their addresses and reply and all that stuff. If a party is unable to file, one expects that an application will be made to court for extension of time, explaining why you're unable to file and seeking the court's extension of time to do so. This happens every day in courts. We all see it. We are all busy people. The court understands that lawyers are engaged in several cases. The problem really lies in when the court gives you that extension or adjourns, even when you are not there or no proper reason or explanation is given for not filing on time. The court extends by way of adjournment for you to file, and you don't file. And having waited for a reasonable period for you to file, an application is now made to close you out. You cannot turn around to say that the court denied you. Our law books are replete with several authorities and patterns. You cannot deny, you cannot say that you were denied fairly because the court has given you. At that point, the other party has the right to call up the records of the court to show that on what happened on each day, you were supposed to come and file your final address and you did not file those addresses. So I don't think that the right to close out a defendant or a prosecutor, whichever the case may be, from filing an address, the court has that right. But it is only exercised when sufficient time has been given for any of the parties, either prosecution or the defendant, to file, and they fail to file. In that case, you are the one who has chosen not to exercise your right. And if you complain, maybe at the appellate court, and the party who was in the matter is able to show the appellate court that you chose not to exercise your right, the appellate court will side with the court, the lower court, and say, yes, you cannot complain of lack of denial of fair hearing because you were presented with several opportunities to do so. You refuse to do so. So I think that's the answer to that question.
Thank you very much, sir. I'm just going to throw this question out there and hope that perhaps Dr. James Agaba or yourself would like to take it. Now, this colleague of ours is confused about how to exercise the right of appeal in a criminal trial where an admissible document that he considers inadmissible has been admitted. He's worried about the time frame within which to appeal. He then says, "Oh, can you raise that issue again at closure, or are you required to appeal that point in piecemeal at that point so that you won't be considered to have appealed out of time?"
Okay, if I may, maybe when I finish, Dr. Gaba, if you have another thought, additional thing to put, you can also enlighten us on it. I think being an interlocutory decision with respect to maybe a document or so that was admitted improperly, you have your misgiving about it. You have a right to appeal against that decision. Now, if you appeal against that decision, it doesn't mean that trial will not be continued. Trial will continue. If, however, a decision is reached, because I know the challenge we have here is that perhaps the Court of Appeal does not reach a decision before the lower court now finally reaches a decision. Obviously, at the point where the trial court concludes using the wrongly admitted evidence, your final grounds of appeal, if it's against you, you can file a decision against that particular what they call it, the final judgment. You can also draw the court's attention by way of maybe the particulars of error in support of any of those grounds, knowing full well that you have an existing appeal. You can also find a way to get this present appeal to be merged with the other appeal if they've not been heard at that time, by consolidating them so that one panel can hear the two appeals. That way, it is easier for the court to take a decision on that interlocutory position, knowing full well it may affect the decision in the final decision. This way, it creates orderliness in our judicial system. I think I always advise lawyers that if you know you have an interlocutory appeal that this decision might affect the final decision of the court, if it has not been fully heard before the lower court gives judgment on the substantive matter, it's advisable when you file an appeal against substantive matter to draw the attention of the appellate court by way of an application to the implication of having those two appeals heard together, the desirability of having the two appeals heard together. This way, you save the court valuable judicial time. And of course, the court can now have an overview of both your interlocutory appeal and the substantive appeal and come to a decision as to how one can affect the other. I think it just makes proper procedural sense to do that.
Yeah, thank you so much. Thank you very much, Mr. Dawes. I don't think I really have anything to add to it. I mean, add too much, but just to agree with you too, and then to say too that you know that the courts have always, the Supreme Court has always said, look, when you have an interlocutory appeal, as much as possible, unless if the interlocutory appeal is capable of ending the proceedings, just wait. If you have any of those issues, just wait until the final decision.
Sure, yes.
Yes, one advantage you will have is that even though that particular document was not admissible, it was admitted, the final judgment may still be in your favor. That saves you all the trouble of going on appeal. Then if it is, if ultimately if the court also give judgment against you, while you're filing your appeal as of right within the time given by the law in respect of the final decision, you can seek leave of the court to also file, I mean, to raise the issue of that interlocutory, to join that ground, the ground that was interlocutory. Because without leave, you can't argue it. So you will seek leave to argue that particular ground. So it saves you a whole lot of trouble. But by and large, the Supreme Court keeps saying, look, don't keep coming with interlocutory appeal when the main suit is pending. Wait, let them finish with all, then you can come, bring everything you have, I mean, for us. So thank you very much. Sorry, Mr. Mayowa, is like a chairman's hand has been up since, or is it my system that is deceiving me?
I can't see. Is Mayowa still here?
I can't see it. I can't see his hands. His hands are not up.
Maybe
in case your hands are up or you want to say something, you should.
Oh,
you have
my hands.
No,
my
no,
hands.
No, not yours. Not yours. I was referring to Mr. Ejikwe. Mrs. AK wants to say something. You have the floor.
Okay. I just wanted to say concerning what Doc said. I have a matter that I'm arguing that the appellant did not raise any objection or did not file an appeal to the court's decision admitting the confessional statement, and so he cannot raise it as the appellant at the end of the case. You know, on appeal now, that he should have appealed against that decision of the court. In fact, the Court of Appeal actually agree with that. We are in the Supreme Court now. You know, that he should have appealed against the court's ruling admitting the confessional statement, even though, of course, it does not appear as a state. So I think the counsel, of course, the defense counsel should think carefully whether defense or prosecution, if there's a particular issue that you strongly believe is fundamental, you know, to the decision of that case, It's the same thing that I think Dope has also said that, Ikoike said that, if you feel it's fundamental, err on the side of caution. I would think I would rather, your appeal, file interlocutory appeal. Does it hurt? Is it going to take anything away from the case? I think not. But I think to be on the safe side, you just go ahead and put in your appeal while you're awaiting the conclusion of the trial. That's my own view. That's what I would do. Thank you.
Thank you, Mrs. Eke. This is particularly interesting because just after we asked that question, a few people have gone into the comment section to type in comments which suggest that they're of the view that decisions on administrative documents or not are final decisions and that they're not interlocutory, and as such should wait, and such persons should wait until the case is concluded, and if they have an issue, formulate grounds around those issues in the final appeal. So it's a good thing Ms. Eke has said this, so that you don't get into a situation where you're caught between whether the decision that you are appealing against is an interlocutory appeal or not. Perhaps it is safer to file that appeal at that point and consolidate, like Mr. Onyeke said at the end of it. Ladies and gentlemen, it appears that we've run out of questions in the questions room. We still have about 15 minutes to go. I noticed a lot of people are asking for the slides. The slides will be uploaded as usual on the various platforms that we have. And like we've always said, these sessions are recorded and are uploaded onto the YouTube channel of the ICLE committee. You can find them there. So at this point, considering that we still have a bit of time, I don't know whether Mr. Eke still has anything to say, or Mr. Yes, sir.
Yes, there's a question on this thing about IPO tendering statement of account of accused that I didn't get it. I came in late. I don't know.
Okay, you want to take that question, sir? Do you want to address it, sir?
Yeah, so something about in case of issuance of dot check, can an IPO tender the statement of accounts of the accused person that was obtained from the bank and signed by an officer of the court? Well, I think if I should say, that is as a part of investigative findings. Obviously, before the IPO can, I would say yes. Yes, in the sense that an IPO has a right to present evidence unaided in the course of his investigation to the court. Obviously, in doing so, he would tell the court about the complaint, what he did upon the receipt of the complaint, writing to the bank, the response of the bank, and what the bank sent back to him. If the circumstance in which he's presenting that statement of account, that is okay. But he's not presenting the statement of account as the banker who is giving evidence on the entries in the account with respect to the way a banker would say, oh, at the time that this account was opened, these are what our engagement with the person opening the account. But for the purpose of saying, I received this document from the bank as part of my investigation to determine whether at the time the person issued those checks, there were funds in that account that should have received, that the check should have gone without problems. To that extent, yes, and it can be cross-examined with respect to the actions that he did upon receipt of that. Obviously, it can also be cross-examined on any conclusion, investigative conclusions he reached on receipt of the statement. Because let's say, for instance, he asked the bank to provide statement of accounts, and the bank provided the statement of accounts. And in the process, he sees that there was no money in the account. Let's say the check was for ₦1 million, and what was in the account was about, say, 400,000, meaning that it was short by about 600. To the extent of the fact that there was only 400,000 in the account as at the time the check was issued, prior to and after the check was supposed to have gotten effect, the IPO can testify on those findings to reach a conclusion that the man perhaps willfully issued those checks. However, if the defense or a question put to the IPO is to the effect that, are you aware that the man had applied for an overdraft from his bank, and that overdraft had been approved. It was pursuant to that approval that he now issued that check. That is not something the IPO may be able to answer. This is why it will be important for the prosecution to present the the banker, so that those kind of questions or those kind of doubts can be cleared. Because if the man had applied for an overdraft and the bank has agreed, it means that the bank is saying, though you have 400,000 in your account, we have agreed to give you, say, ₦1 million overdraft. You can draw monies beyond and above what you have in your account to the tune of ₦1 million. And if there's proof that that has been approved, obviously the confidence to issue that check now falls into one of the defenses available to the man under the Dutch Act, which says that a reasonable expectation of funds, because it is reasonable in that circumstance for the man to assume that his bankers having agreed and approved his overdraft, and a check of 1 million would go without problems. So I would say yes to the question. I also say that it's always better to have the banker come in to establish that in the circumstance of this account opening and all the transactions between us and these parties, there was nothing like overdraft or loan that should enable the man be issuing checks, knowing full well he doesn't have funds in his account. That would be my answer to the question.
Thank you very much, Mr. Onyeke. We're going to go back to the interlocutory nature of objections, appeals of objections to administrative documents. It appears Mr. Onyeke wants to say something, but I should let you do that before I go on to the next question.
Okay, if that's fine. I just wanted to say that generally that in a final address, it's important for counsel to keep in mind that each defendant stands alone. There is a problem sometimes when you have a defense counsel representing 3 persons and they want to do a final address, have a general address for all of them, similar defenses. It is possible that one of the defendants will be discharged, but the others would go in for it, would be convicted. So same goes for the prosecution. Each defendant, the case against each defendant must be outlined in your final address. So also for the defense, you have to do the same thing. Recently, we successfully argued that the fact that one of the defendants was discharged by the court does not automatically entitle the other 2 defendants to discharge. And now here's the scenario. We had the prosecution had called the IPO. They tendered the statements. There were confessional statements. They were all admitted for 3 defendants. Now, at the point of cross-examination, initially one counsel appeared for the 3 defendants and I failed. So at the point of cross-examination, the counsel for the first and second defendants cross-examined him, and he failed to. The IPO maintained his position on those statements tendered. Then before he was the 3rd defendant, suddenly got another lawyer, a younger lawyer. He came to court, asked a few questions of the IPO, and the IPO admitted that actually there was nothing against the 3rd defendant. This was a star IPO that had withstood cross-examination by the field for the first and second. In fact, in that case, the court got so upset. There and then, the judge discharged the defendant, the 3rd defendant, there and then in court. He didn't wait for final address or anything. And of course, he's empowered by the ACJL to do that. He discharged the 3rd defendant. So the other defendant, first and second, they put in a no case submission and said, because the IPO had admitted in court that there was really nothing, he didn't really investigate, that aspect concerning the 3rd defendant, and the court had discharged him, it means automatically that the first and second defendant should be discharged. So the same, of course, the no case submission was overruled. Even in the final address, it was also argued But the point that we strove to make, which the court actually accepted, was that they found that the IPO, he wasn't, perhaps his evidence or his cross-examination led to the discharge of one of the defendants does not mean it necessarily applies to the other two. So basically, you have to address the case of each party, each defendant on its strength and not lump them together. This goes for both the prosecution and for the defendant. Then the other thing I want to say finally, for the prosecution, now what I would do, what I usually suggest, when you have your final address, first, don't waste your time talking so much about the defendant's his case, talking about what he said in court or what he didn't say or how he contradicted himself. But first focus on your case and outline how you have been able to prove the ingredients. Then the second part of your address, you can now address the issues concerning the defendant's own case. But first, two things I've said. Each defendant stands and falls on his case should be addressed. The final address should not be lumped together. Every address should look at the evidence against each defendant. And then secondly, that the prosecution should always attack his case, prove his case first before he goes back to talk about what the defendant did or he did not do in court. Oh, then let me also confirm that it is possible to also have the confessional statements admitted. I have had a case where, in spite of the confessional statements admitted, at the end of the day, the judge ruled that, because of other circumstances, and it didn't quite tally, the confessional statement couldn't be supported by the weight of the other evidence, and the defendant was still discharged. So defendants should not lose hope because a confessional statement has been admitted. Statement and extrajudicial statement has been admitted. You keep fighting it until the last, and you may very well, find out that there is no weight that can be attached to it. That's just all I want to say. Thank you.
Thank you very much, Mr. Zeke. We'll just take one last question before we go, and I'll address it to Mr. Eke. Now, this question appears to have been asked by counsel who is holding brief in a criminal matter. She would like to know what counsel can do in a situation where the IPO or prosecutor is stalling the case because they are requesting for mobilization from the complainant. It's not a legal question per se, it's a worldview experience question. You need to unmute yourself, Mr. Eke. You need to unmute yourself, sir. Can the admin unmute him remotely from where they are? It looks like he's the problem with his device.
Okay, good. I'm okay now.
All right,
you
sir.
Can hear me now?
We can hear you, sir.
Okay, good. I think I want to assume the question was asked by somebody who's acting for the defendant, because that is when such delay would matter to him. So if that's the case, if there's been what I do, when faced with such a situation, the first time they cause a delay, I would just agree with them and perhaps align with their reason and seek for an adjournment and ask the court to grant the adjournment, because that's probably the first time they're asking for such. I will pretend as if I'm not aware of any reason for the delay. You wait.
Sorry, Mr. Eke, I'm going to interrupt you. Apologies. The question is being asked by somebody who is holding brief for a complainant. Not for the defendant.
Okay. Not for the defendant. Okay, good. Well,
yes.
I think
holding brief for the complainant,
case,
and the issue is that they're trying to ask them for money, and because of that, they're stalling.
Okay, thank you very much for the clarification. I think if that is the case,
Sorry,
it's
please
always
let me get,
better.
Mr. Jeke, please let me get the question correctly again so that I can follow properly. Are you mean holding brief or watching brief for the
I think it's
company?
what you should.
Watching brief.
I think it's
Watching brief
brief
should
for the
be.
company.
Watching brief. Sorry,
Uh-huh.
sorry. Apologies for
Yes,
the
it
wrong
should be watching
terminology.
brief.
Watching brief.
Yes. Hello? Can you hear me?
I can hear you.
Okay, good.
We can hear you. We can
Okay, good.
hear you.
So if it is a case of watching brief, it's not a big major problem. Once you discover that it is the way they are operating, the best thing to do in that circumstance is to deal with it administratively. Because a counsel watching brief has no voice in court. That is the position of the law. He can only get up and say, I'm watching brief for the nominal complainant. He cannot make arguments that the court would accept, even if the court is seeing him. He's only there to watch brief, and perhaps anything he has to say, pass it on to the prosecutor. But if it is clear that the prosecutor is acting in cahoots with the IPO in failing to assist in presenting their case, it's only an administrative action that can be taken by either reporting, if it's the police, report to whoever is the police, the authority above the prosecutor. If it is at the state level, bringing it to the attention of maybe the DPP or the supervisory counsel for the person who is coming to court. A complaint administratively should be able to deal with that issue without necessarily it being something that can be brought to court, because there's really little the court can do. The court cannot be seen at the stage of the prosecution presenting or not presenting its case, assisting to make orders that would compel prosecution to bring case. That would be as if the court has taken a side. The court is to listen, not to take a side. If there are difficulties that are trial related, then the court can assist by making orders that maybe you are looking for a subpoena and all. That's when the court can come in for either party anyway. But for things like police is refusing to come forward because they want money, I think it's only administrative way it can be dealt with. Like you said, it's not a legal question, it's just a question on experience of what you have seen in the course of the trial. And that's why I said administratively is the only way you can deal with that. Mayowa, if you would permit me, there's a question I saw there where somebody said their network had a challenge when I was talking about how to present the final address and the use of English. If I recall the question being asked and wanted a recap. I think all I was trying to say there is no more than what Dr. Agaba said, which is English is the tool with which we do our work as lawyers. Like when we were in the university, we used to say literature is the mathematics of English. Because if you know literature very well, if you are good in literature, it helps you on how to write long essays. Final addresses or even briefs are all long essays. So you must be, it's like writing a novel. So you must be coherent in the way you start writing it from the beginning so that the person who is reading it from the beginning can make sense even in the middle and follow it up to the end. It's all about delivery. So what I was trying to say was not like teaching anybody a proper form to use or English to use. I was only saying that as lawyers, we should be masters of the use of English language in presenting our client's case. And in doing so, you must know how the use of English, those things they taught in university in ELS 101 or something like that, where they tell you topic sentence. Once you take a topic in a paragraph, address fully what you want to say, know when to use full stop, know when to use comma, know when to use the apostrophe. All these things are very important because when someone is reading your brief or your final address or any written address, there should be a way the person can stop to breathe, which the comma is supposed to do. There should be a place where the person should say a full stop so that they can take a breather and continue reading, so that it will not be as one continuous sentence that does not have a place is stopping and a place it is ending. It just models up the thought process and what you're trying to say. So it's all about going back to the basic, learning English. I would say for people who are having these difficulties, go and read novels. I think if you develop the habit of reading novels, read good novels, you will see the way the authors use these things in conveying their thoughts. I mean, for you, somebody to sustain a book from page 1 to some novels are about 400 or 500 pages, and you don't want to put down the book, it's simply because it's able to take your mindset and transport you into the book, and you are following the entire exercise without getting bored. So if you read novels consistently, over time, it will assist you in how to use your paragraphs, how to use your comma, your full stop, your how to just write long essays without being boring, and how to put your thoughts coherently. So I don't know if the person who asked the question is satisfied, but I would say that the best thing for you to do is go and learn, take some precedents of final addresses written by very established lawyers, and see the way they try to marshal out their thought process and begin to mimic the way they write to the extent of the form, not the language, because at the end of the day, you must be comfortable with your own language. Thank you.
Thank you very much, Mr. Eke. At this point, we would bring today's session to a close. I'd like to thank all of the panelists on behalf of the ICLE committee. It's been really been a lovely and enlightening session that we've had today. A lot of our colleagues are asking questions about the slides for today's presentation. Some of you have indicated that you haven't received the slides for the previous presentations as well. I assure you that the admin team would ensure that you get them. A lot of people are sending their emails and saying, send it here. You don't need to do that. When you register for these sessions, you are required to fill in your email addresses. So it's captured at the back end. We have all of that data. Everybody will get this thing in due course. We apologize for the delay. We'll try to speed up the entire process. Some people have also indicated that they haven't received their certificate for the CPD points. I can assure you everybody will get theirs. At this point, we would adjourn till tomorrow for tomorrow's session. Tomorrow's sessions will hold between 12 noon and 2 p.m. in the afternoon. Thank you all for joining. Please enjoy every bit of your weekend. See you all tomorrow. Bye now.
Thank you so much. God bless us.
Bye, Dr. Agaba.
Thank you.
Bye now.
Bye. Mr. Docs, thank you.
Well done, Doc. That was a very good one.
Thank you. Thank you.